Welcome back to Patricia's beautiful sunset view. We're here for the afternoon session. Are we there yet? Hey, Kimmy.
My real-time viewer is working again.
Hey, Sharon.
All right, welcome back, everybody. It's after lunch now. We're all back in 2020 CF 3014.
Hey, Circles.
Is there anything we need to talk about before the defense calls its next witness?
No. It was a very boring morning
All right.
in this
As soon as
trial.
the jury comes up, let me know and we'll bring them on in.
I am so hoping that the defense rests and we get some argument. But I know they definitely have 4 witnesses. I don't think I've seen more dead time and sidebars in a trial than we saw this morning.
All right, y'all can sit down. Welcome back, everybody. As we were breaking, I saw some folks got new pads of paper, and everybody's pen is still doing okay? All right, just let us know if not. I hope you had a good lunch. Did anybody discuss the case amongst yourselves? Talk about the case with anybody outside of this group, or do any research on people, places, things, or legal topics, or get any information about the case?
No, sir.
Everybody says no. All right, Mr. Taylor, call your next witness.
Thank you, Judge White. Defense calls Justin Warren.
Okay, Justin Warren.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
This guy's on the prosecution team. He's been in the background the whole trial, right?
Just make yourself comfortable in that chair. Right? Get about 12 to 15 inches from the microphone. Just up, down, left, right, however you need. Loud, clear voice, and we'll hear everything.
Yes, sir. Your Honor, with the court's permission, permission to treat as adverse.
You can go ahead and approach.
Look at the permission to treat as adverse. So, and then the judge puts his head in his hands and he's like, "Oh my God, another conversation." I want to make sure I understand where this witness is coming
Justin
from.
Warren.
No, not the same guy as on the team. Okay, sorry, I got the guys confused. Not the same guy.
Yourself comfortable in that chair.
Look at the
you can go ahead and
judge.
approach.
Head in his hands. Oh my God, not another conversation. Another sidebar. Every time a new you can tell that the judge is pissed off. So what it means, I should look up the precise legal definition, but basically what it means is that an adverse witness is somebody who the party that's calling the witness is calling the witness, but they might be a witness that is known to be for the other side. So I think the ordering of question or the way the questions are sometimes come out like there's a slightly different procedure to the questioning when the witness is adverse.
Bless you.
Detective Warren, good afternoon.
Good afternoon, sir.
You were the lead on this case, were you not?
Yes, sir.
Will you tell ladies and gentlemen of the jury, what does that mean, the lead detective?
The way that our unit works, the Manatee Homicide Investigative Unit, the lead essentially during a homicide investigation is elevated to essentially almost the rank, not a sergeant, but basically has some of the same responsibilities as far as handing out assignments and then collecting the information in the end.
And is amongst the ones with the most knowledge of the case. Would you agree?
We do collect everything at the end, but we do have meetings, so everybody's pretty much aware of what's going on.
All right, does the lead detective develop the theory of the case?
We work as a group, so like I said, it's pretty much a group effort.
Right, Friday. Slow Friday. But the judge didn't rule, didn't, at least to us, whether this was an adverse witness. So I don't think he is
Do you recall
an adverse witness.
being asked the following question on May 16, 2023 at a deposition? Question, okay, so part of your responsibility as the lead detective, you would develop a theory of the case, would you not? Answer, sure.
The answer is still sure. Yes, sir.
You want your investigation, especially for homicide case, do you not, Detective Warren, to be objective and fair,
Yes, sir.
with conclusions supported by evidence,
Absolutely. Yes, sir.
not speculation?
That's correct.
It's not something, given the nature of what a homicide investigation entails, that you want to jump to conclusions.
That's correct.
Did you submit an arrest affidavit for Ms.
Objection.
Benefield?
Pretrial rule.
Just asking the question.
Ruled at this point.
Did you submit an arrest affidavit for Ms. Benefield?
Yes, sir.
Did you represent that
Objection. Pretrial rule.
Sustained.
did you describe
Objection. Pretrial rule.
Go ahead and ask your question.
Let me ask you this. Was it your position that based on the entry wounds to Douglas Benefield, that it did not appear he was facing Ashley Benefield when he was shot?
Based on what I knew, yes.
And as it related to the chest wound, what did you base that on?
Well, whenever we have a homicide investigation, one of our detectives will go to the medical examiner's office for the examination and obtain a preliminary finding. We don't actually receive the medical examiner's report for several months to maybe even a year in some cases.
You're aware that the medical examiner's finding here was that he was shot from
Objection.
the front.
Hearsay.
Sustained.
As it related to the wound to the leg, Detective Warren, what was the basis for your conclusion?
I'm sorry.
As it related to the wound to Douglas Benefield's leg, what was the basis for your conclusion?
It appeared that he was shot from the right side of his body.
Can we agree that you got both of those wrong?
I wouldn't say so, but that, like, I'm not a doctor. I would ask the doctor.
Okay, so it's your position as you sit here today that Mr. Benefield was not shot from the front.
That's not the way that it appeared when we did our preliminary investigation with the medical examiner and then later on.
And it's your position today as you sit here that
Objection, Judge, can we approach?
So I think what the defense is getting at is that this detective determined that, and this is why obviously they charged her with murder, is that Doug was not shot from the front, he was shot from the back. Which would be the reason that they would determine it's a murder, rather than self-defense, and would determine the charges and what's being argued. The doctor that came in and testified, the medical examiner, said that the wound went from front to back and side to side. So he said it was primarily in her, hit him in the front. It didn't hit him in the back. It hit him in the butt, in the front. But it traveled through his body, through diagonally from side to side. Yeah, I've noticed that, it's interesting. I've noticed that other defendants also get access to those headphones so they can listen to sidebars, but not all of the defendants listen to the sidebars. So, Johnny, this detective determined that he was shot, that she shot him. That he was not shot from the front. Okay. But the doctor said no, he was shot from the front and the side. He was turning. The listener can surmise that Doug was turning at the point when he was shot. Patricia says, I think the second shot is indicative of Doug trying to hit the deck, as in trying to get down low, which is a natural reaction to the sight of a gun. Yeah. Like he was ducking and running, and somehow it hit his leg. And the doctor also said that the wound to his leg was consistent with him running, kicking to run. So I think the defense is trying to get this witness to say, oh, I think the line of questioning that this defense lawyer is trying to do is, in your report, you said that he was shot from the front. Would it surprise you to learn that the medical...
All right, here's the jury. I'm going to need a couple extra minutes to handle this one. If I could ask you to step out, close up your notes.
Oh, boy.
Step back in the jury room. We'll get you back as soon as we can. Remember, don't begin deliberations, talk with anybody about the case, or do any research on the people.
Your Honor, I would like a sidebar here. Is this, Your Honor, sidebar?
There's no jury room.
Okay, well, that's me.
We do a sidebar to keep a jury from hearing things, but there's no jury.
Sidebar. Yeah, maybe he was trying to dive.
All right, sir. We're going to need to address some legal matters about your testimony, so I'm going to ask you to step out into the hallway. The rule of sequestration has been invoked, so you're not to discuss questions asked of you or your testimony with anyone. You're not to talk with other witnesses about their testimony, the questions asked of them. You're not supposed to do any research about the case or watch anything.
Yes, sir.
All right, the witness is out. So there's, as I understand it, there's going to be several areas of cross-examination regarding Detective Warren. And the state has objected on the longstanding doctrine that you can't call a witness solely to impeach that witness. So that's where we're at. And the line of question where we stopped was going to involve statements made by the detective in his probable cause affidavit or arrest affidavit. All right, so these issues were addressed, and I seem to recall that I allowed these at the stand your ground hearing, and this may have been the footnote where I said rulings at trial may be different. And there's also been a pretrial motion regarding impeachment of Detective Warren and what is relevant and material and admissible. And I said, I believe my ruling was that it would have to be shown at the time of the cross or the direct and the attempted impeachment to show that those criteria are met. So, State, what else did you want to put on the record?
Judge, only that this keeps happening, and we did hours of litigation about these issues so we would not have this problem in the middle of trial. Now, almost every sentence that comes out of Mr. Taylor's mouth, I have to object because he is not following your rules or the rules of evidence. So I would ask that we try to get this ironed out now so we don't have to call the witness back and I have to object 5 more times. He has clearly only called this witness for impeachment purposes. That is the A1 first objection that I have.
Sure.
All right, I called this witness to establish substantive evidence. I asked him, what does being the lead detective on a case mean? Is that the one who has the most knowledge of the case? Do you develop a theory of the case? He resisted that. I impeached him with a prior acknowledgement. He then also said and confirmed that he would want his investigation to be objective, fair, with conclusions supported by evidence, not speculation, and that it's not something that you would jump to conclusions on. Now, that is my substantive evidence predicate. And based on that alone, if nothing else, I am now allowed to argue to the jury, don't you think it's strange that the lead detective on a homicide case would not be called as a witness on behalf of the state? So that's my substantive position. Along the way, I should be also likewise entitled to impeach him. For example, he has testified that you would not want to jump to conclusions on a murder case. You'd want it to be objective, fair, conclusions supported by evidence, not speculation. All right, fine. Is it not true that within an hour and a half of this shooting, you referred to this as murder? I then want to ask him, do you believe all homicides are murders? If he says yes, good. If he says no, then I plan to impeach him because he made that statement in his deposition. I then want to ask him, and do you believe that all people who kill are murderers? If he says yes, fine. If he denies it, then I plan to impeach him because he made that statement in his deposition. I don't see why that is not a fair game, respectfully. The only other question I had of him was he had authored a supplemental report
APKC.
on November 16th of 20. And in that supplemental report, there is a provision on the report for bias, referring to the subject, Ashley Benefield. And he checked the box, or either checked the box or wrote in no bias. I plan to ask him about that.
And what report is that?
That is a report that he authored, a supplemental on November 16th of 2020. And referring to Ashley Benefield as it relates to the victim, Douglas Benefield, he wrote or check the box that says no bias.
What are the other options?
Well, the other options are hate, spite, ill will, and
On that form?
no, the form it's an open form. It's for him to put it in there. Here, I'll show the court the form.
Hey, musician mom. What the hell is he trying to get in here?
Which,
It says bias motivation, he types in none, no bias. The next block says bias target, it's blank, and the box after that says bias circumstances, that too is left blank. Would you like me to show you?
Yes.
first, I don't think he filled that out.
Even if he did, I don't know what.
No, I will tell the court in deposition, Detective Warren questioned whether or not he had filled that form out, despite the fact that it's got his name typed on it. That's going to be a question of fact for the jurors. It goes to its credibility, not its admissibility, respectfully.
I'm sorry, but I'm sort of missing what the importance of it, of the bias, no bias comment is. Did anyone else catch what the importance of that is?
All right, the line, thank you. The line of questioning that you seem to be starting with was the line of questioning at the stand your ground hearing where a narrative was established. And then I believe it was shared with the state, and then there were some amendments, and then it was shared with the state, and then there were some amendments, I think, to final form.
All I proposed to ask him here was, did you write a witness, hit Ms. Benefield with a box? And I want to ask him if he knew who that witness was. And he's going to tell me it was Doug Benefield. And I'm going to ask him why he didn't say that. Give us a reason why you would not have disclosed that rather than put a witness.
Oh my gosh.
Judge, I feel like we litigated all of this. And this was supposed to be shown to the court outside of the presence of the jury so you could make a
Hi, Kate.
pre-determination before the jury came out. I would like to know the relevance of what is in his arrest affidavit. He cannot call a witness to the stand and say, do you do a thorough and fair investigation just so he can impeach him with this stuff that he's trying to get in. He calls him and says these questions and calls them substantive evidence. It's not substantive evidence. It is setting him up so he can get in all of these items that he thinks are impeachment. We have gone over this before, that what is in this arrest affidavit is irrelevant. What the judge signed the arrest affidavit. You said in your pretrial order that the use of the word murder versus homicide, my motion was granted unless this defendant can establish to the court why this is relevant. And the defense did not say anything different than what they said before when we argued this. Also, any edits of a warrant or search warrant or anything in the warrant, same thing. So I really don't understand why we're back here arguing this again. The arguments are exactly the same. He calls this witness, asks a few questions to set up impeachment. It is disingenuous to say that this witness is called for anything substantive other than attacking his credibility. He was never a witness. Why is he attacking the credibility of a witness that never testified?
So as I understood the
Final
court's ruling, until such time as I could demonstrate the relevance of it, it was not admissible. I think the relevance of the lead detective believing that all homicides or murders is overwhelmingly relevant.
Please explain. I understand, and you said that multiple times in multiple hearings.
Yeah.
Relevant to prove what?
Bias. This guy executes a search warrant within 45 minutes of the shooting, referring to it not as a homicide, but as a murder. We've already had testimony from at least 2 deputies, and in particular, I'll remind the court of Lieutenant, I believe it was Dickens. Who? Dickerman. Who testified that not all homicides are murders, that the reason you have to take time to investigate a homicide is to determine whether or not there's been criminality. So here's the lead detective who initiates the theory of the case. Within 45 minutes, he's calling it a murder rather than a homicide. And he makes the statement that all homicides are murders and anybody who kills is a murderer. And the court is going to instruct the jurors, if you feel her action was justified, then she's not guilty, because not all homicides are crimes. How could that not be relevant?
This witness never testified.
Any further thoughts?
No.
All right. Yeah, these we've already covered this ground. So it answered a question just a moment ago about what was the purpose for calling this witness. And the law is very clear. And I think both sides know this area of the law. You cannot call a witness solely to impeach that witness. Asking if that person is the lead detective, is it important to be fair and objective? Is it important to rely on facts? Is it important not to engage in speculation or jump to conclusions? Those are not substantive questions regarding the investigation. Those are just general questions to someone about being objective and fair. In this particular situation, and I'm skipping over the part about any argument about the state not calling the lead detective in a case. I'll leave that to whenever it's presented. I think we all know the law on that as well. But the answer I got is, what is the relevance of him referring to, in a search warrant within an hour and a half, a murder? What's the relevance of his opinion? This is an opinion. Are all homicides murders? That's an opinion. It doesn't matter what he thinks. If he thinks that all homicides are murders, or all murders are homicides, or there's some mix of the two of them, that's a jury question that the jury is going to have to answer. I can't think of any witness I would let speculate or testify as to whether this case is a homicide or a justifiable homicide or an excusable homicide. That's the province of the jury.
Judge, can I ask?
I tried to give both sides as much time as they wanted to put information on the record. The question, are all people who kill murderers? Again, what I'm asking is, what's the relevance of that to show his bias? There hasn't been anything established that he was particularly biased in any way, or how that would be relevant to this particular case when it's an opinion whether people are killer murderers. That's going to be a jury question to decide whether the state has proven beyond a reasonable doubt its allegations of murder in the second degree with a firearm, or if the facts and evidence support a lesser included offense, or if the state has not met its burden and the defendant is not guilty, whether they haven't met their burden or because the jury believes and finds that the defendant has acted in lawful self-defense. The other issue about the statements made in the probable cause affidavit, it's my understanding that's going to be asked is, did you know who that witness is? And again, I'm struggling to understand how that is relevant into any particular issues in this case.
How about this, Your Honor? Does the court think if, as the lead homicide detective, Justin Warren would have said, I'm not going to
See, when a defense attorney is going back and forth with a lawyer, I'm sorry, with a judge, and the judge is basically denying him something, and the lawyer comes back and says, "Well, how about this?" You know, he's just throwing shit at the wall. You know that's where he's at in his case, where he's just trying to think around and slip through legal loopholes. And I think that's what we've been witnessing this whole trial is this very crafty, very experienced defense lawyer wiggle through all kinds of legal loopholes to get in arguments and witnesses. And that's what he tried to do here, and the judge is irritated.
Seeking a search warrant because I think Ashley Benefield was abused and I think her actions were justified. That would be his opinion. But if that was his opinion, she might not be sitting there right now. That's why I think it's relevant. He initiated the prosecution. And you were hearing from somebody who initiated the prosecution who is overwhelmingly biased. He acted impetuously. He acted without evidence. He got both of the entry wounds wrong. He completely speculated that Mr. Benefield was not facing her when she was shot. Their own medical examiner said he was facing her.
No, he didn't. He didn't say he was facing her. That's very misleading, and
State anything else?
I don't like about this defense
No, sir.
attorney. He's very misleading.
Mr. Taylor, I am certainly giving you as much room as I can to cross and impeach on relevant and material issues. But from what I've heard so far, and I will just say that the impeachment from earlier regarding theory of the case, that was not materially different. But so far, the questions you have asked and the questions that I've heard you represent to me and issues that you intend to represent and question this witness on are all impeachment issues.
All right, I have two questions remaining. Will the court allow me to ask them? One question is, I want to ask him if he spoke with the medical examiner before he submitted the arrest warrant. And the last question is, did you fill out this supplemental report and indicate no bias? That's it. Then the only thing left is I want to show him the DNA report and have him read the section that's applicable. We gave them business records notice.
Okay. I have,
Well, hold on.
okay.
The two questions that have been stated at this point, the two questions, just to try and get objections out of the way and get them ruled on so we can get this going, is one, two is this supplemental report, nothing regarding bias. And the first thing again?
And the first one was, did you speak with the medical examiner before you submitted the arrest warrant? I think he's already testified to that.
I think he did.
None of it is relevant, Judge.
All right.
And I will be asking for a curative instruction depending on the court's ruling.
All right. And then you wanted to show him
The DNA.
DNA report.
Yeah, he submitted the exemplars and he got the report back.
All right. I don't know if I've seen that.
You may not have. We'll be happy to show it to you if you like.
But what is the relevance of showing a detective a DNA?
Hold on. Yeah. Plus it's a report. It's not been authenticated.
We gave them the notice of the business record. They did not file an objection to it. And it shows that
PKC, this has been a rather confusing trial, especially today. because there's been a lot of different there's been a lot of disruptions, a lot of sidebars, and part of the reason for that is because Ashley and Doug had a, custodial family court issue before this, and then there were, protective orders and things like that. And there were all kinds of pretrial motions determining what can be kept in, what will be brought into this case and what will be kept out. And they have to talk around those rulings. They have to not bring in, in other words, like Patricia says, a lot of bullshittery. So there's just, it's been very frustrating to watch, and it makes things very confusing and probably doesn't give us as the audience the full picture. Let's see what this defense attorney is saying.
That says there's
I'm
DNA
sorry,
from
what?
Doug Benefield or Ashley Benefield is hearsay. There's not a person at DNA Labs that can say where those swabs came from. They all they know is they got them from the sheriff's office and somebody told them where they came from. And I think that the probative value is outweighed by the prejudice because it's going to confuse the jury. It's a packet with bench notes and the report. And the report, there's no witness here to testify to explain a very complicated report. This isn't, even ballistics is somewhat simple. This is DNA. It's extremely complicated. And I think that the danger is that it will confuse the jury and that the proper foundation has not been laid. So my objections are not to the business records, which is why we did not file an objection. It is to the contents being hearsay. There's an insufficient foundation to enter this, and that there's a unfair prejudice.
I'm quite comfortable relying on the court's notes, and if the court checks its notes under Megan Dorvac, the court will see that Megan Dorvac testified after being called by the state that she swabbed at the sheriff's office that evening Ashley Benefield's hands, arms, and forearms for DNA evidence. And I even specifically asked her if the purpose of that was to be able to determine who may have touched her on that occasion. She agreed. Now, Warren submitted those DNA samples to the lab. The lab returned those DNA samples to Warren. Now I'm going to ask him what the result was. And I have the DNA report for the court if it would like to see it along with the business certification records of the custodian.
I see plenty of them. All right, anything else?
No, Judge, that's not how any of this works. There's been no swabs. There was no witness that said, these are the swabs I took from Ashley Benefield. There's been no witness that said, these are the same swabs that were sent to DNA Labs. There's been no witness that said, those are the swabs I received. There's been no establishment that anything in that report is related to this case based on anything other than hearsay, which, I'm sorry, I already said all those things, but it's just frustrating because they're all the steps to get that reported under certified business records have been skipped. And so although I don't object to that portion of it, it's the contents being hearsay and improper.
As the proponent, I'll give you the final word, and I need to make a ruling.
Well, just say the state never filed any objection. We gave them notice plenty of time.
That's fine.
Yeah, this is a really easy call. That lab report is not admissible. You could call the DNA analyst who could come in under 9702 and establish the foundation and the bases to admit DNA evidence. After the chain of custody has been established, there's been no evidence. I haven't heard anything at all about the I heard about swabs. I don't recall seeing the swabs. I heard about swabbing being done, but then the chain of custody, getting them to whatever lab did the testing to ensure the integrity of the evidence. Then at the lab, what are the testing processes, procedures, known error rates, all of the foundations you would need under 90.702 and 703, 704, 705 about how this all happens. And then of course, we need the analyst to explain what these results are. So that lab report doesn't come in. In addition, it's prepared in anticipation of litigation. I mean, that's the whole reason it's done. So that one, that was an easy one. That is going to be prohibited, crossing Warren on the DNA report. The other two, though, the state objects. I think it's fair to ask Detective Warren if he spoke with the medical examiner before he sought an arrest warrant. And you can ask him, I think, if that's his supplemental report. I think it's close, but I'll let you ask him, here in this box regarding bias, nothing is there. But out of everything I've heard, those are the only two questions that I think are relevant and material and appropriate of everything we've talked about, and aren't solely to impeach. So,
And-
all right,
And Judge, I would just ask to establish the without bias part without speaking it out loud to the jury first.
I don't understand what that means.
He's leading this witness and speaking what's on the report before the witness even says he wrote it or anything. So
Right,
I
so
would prefer that he not.
establish if it's his report, establish that down on, right here, there's a box that says a bias. What does that mean to you? And he left it blank, and is there anything in particular that why he did that? But that's the extent of what I've heard relevant. So let's bring it back in.
Yeah, I just saw a notice about that. It was like it's a Taylor Swift related event, not an actual concert or anything, but at a Taylor Swift related event, a bunch of people got poked. And I think both it is happening more and we are hearing about it more. I think it's both. Solo. I think people get inspired by other people's actions. Stay safe from the fires, PKC. Ages 2 to 6? Oh my God. But are those the ages of the victims too? Holy crap, man.
Everybody says no, you may resume your direct exam.
Thank you. Detective Warren, did you speak with the medical examiner yourself before you submitted your arrest warrant in this case?
Well, like I said earlier, we have a detective that will go to the scene or to the medical examiner's office to get the preliminary findings.
Let me repeat my question, Detective. Did you personally speak with the medical examiner before you submitted your arrest warrant in this case?
Not that I can recall.
All right, let me pass this to you and see if this refreshes your recollection.
Sure. Okay. Yes, sir. Yeah, so I spoke to him on October 29th in reference to stippling.
You documented in your report, did you not?
Yes, sir.
All right, my last question, Detective. Do you recall filling out a supplemental report on November 16th of 2020?
I filled out a lot of reports, sir. But may I look at it just to verify? Okay.
Is that your report?
It appears to be. Yes, sir.
All right, can you tell us the date of the report?
November 16th at 15:10 hours.
November 16th of 2020?
Yes, sir.
All right. Let me ask you if there is a provision in this report for you to note whether or not any bias or motivation is demonstrated by the offender towards the victim.
It's a program that's got a lot of different stuff, so there could be possibly, sure.
All right, let me ask you this. Under bias and motivation,
Okay.
did you put in none?
Well, it would have just been not filled out. It auto-populates. Like I said, it's a program, and I'm not a programmer, so I apologize.
So if you had been aware of bias on behalf of Ashley Benefield towards Doug Benefield, such as ill will, spite, evil intent, things of that nature, you would have noted it, would you not?
Honestly, it probably would have been just documented in the report.
No further questions.
Cross.
This section that says bias, isn't this for hate crimes?
Yes, ma'am. When we fill out certain areas for certain crimes, it's required for statistical reporting of things, and a lot of things that I'm not even aware of. I don't typically pay attention to that box,
Okay.
but
So this box is for those kind of statistics, not for any kind of bias that may be going on in this case.
correct.
Thank you.
Redirect.
Do you think it odd that you're the lead detective? In this case and
Objection
you weren't called
beyond
by
the scope.
state?
Sustained.
No further, nothing further.
Can this witness be released?
Yes.
No.
You remain under subpoena, sir. The instructions I gave you about sequestration remain in force.
Do I need to stay in the building, or can I leave?
No, sir, you can go, but you
Okay.
need to be available in case somebody calls you.
Yes, sir. They have my email. Thank you.
Call your next witness.
Try to come back to it. We call Dr. We call Michael Hay.
I remember them mentioning the name Michael Ford. Casey, I bet they haven't just determined whether it's political, but that may be an assumption because of Taylor's support of the left.
I do. Thanks, sir.
No, sir.
Appreciate it.
My name is Judge Ryder, presiding. Make yourself comfortable in that chair. Get about 12 to 15 inches from that microphone. You just up, down, left, right. There you go. Just speaking a loud, clear voice, it'll pick up everything.
Thanks, sir.
Good afternoon. Will you tell us your full name, spell your last name?
My name is Michael Haag, H-A-A-G.
What type of work do you do, Mr. Haig?
I'm involved in forensics. Specifically, a typical job title would be forensic scientist.
Let's talk about your educational background. Where'd you go to school?
My formal education is as a chemist. I have a Bachelor's of Science degree in chemistry from the University of Arizona in Tucson with a math physics minor.
When you speak of forensics, what are we referring to?
Forensics in the broad scope simply means the junction or the joining of science and the law. So it's where somebody who is particularly interested in or has been trained to examine physical evidence brings findings or an interpretation of that physical evidence into the courtroom.
Could you describe your forensic career history for us?
My background and training is fairly unique in that I grew up in this field. My dad, Luke Haag, also does this kind of work. So even in grade school, I'd go out and assist him with both casework and research, and I got the bug. So after I went to college and got my degree, I went and worked for a private consulting firm that he ran for about 2 years or so, followed by an application and employment with the Albuquerque Police Department Crime Laboratory, starting in about 1998. With APD, I worked for about 25 years and got to the retirement point and was able to retire. But during that same time frame, I also ran my own private company, specializing in my sort of primary area of interest in forensics, which is shooting incident reconstruction. The study of the physical evidence relating to shootings, the interpretation of that physical evidence, and the reporting on it, of course. With the Police Department Crime Laboratory, I wore quite a few hats. Primarily, I worked as a firearm and tool mark examiner, which someone in that role particularly focuses on the physical evidence relating to those things. But I also worked in drug chemistry as well as blood and breath alcohol, and was a supervisor of those units for about 12 years as well.
Any additional training and or classes that you have taken in order to be skilled at your job?
The list is fairly long. Honestly, I don't remember everything that I list on my CV. But as far as training and expertise, I've been trained and taking classes from everything from the FBI at Quantico to doing cross trainings with the San Diego Police Department, in-house training with the Albuquerque Police Department. I regularly attend conferences and seminars. I worked for the German Bundeskriminalamt. If you spell it, Bundeskriminalamt, which is like their FBI. So I interned with them for a while before I came to the Albuquerque Crime Laboratory, and a wide variety of other trainings I received over the almost 30 years now.
Are you a member of any professional organizations having to do with your specialty?
I am. The ones that are particularly relevant to what I do would be the Association of Firearm and Tool Mark Examiners, or AFTE, the American Academy of Forensic Sciences. EMFSI is one that I've been a member of for about 2 or 3 years. That's the European Network of Forensic Science Institutes. They actually have some very, very interesting perspectives on forensics, among others, including the Association for Crime Scene Reconstruction. But that's another bug I got from my dad, is being very active in the field, seeing how other units do things, as well as participating in those conferences.
Have you authored or published any scientific papers?
Quite a few. Another bug I got from my dad. I publish very regularly in scientifically peer-reviewed journals, such as the Journal of Forensic Sciences, the Association of Firearm and Tool Mark Examiners Journal, amongst others.
Written any textbooks?
Luke, my dad, and I wrote a textbook, one of the few on shooting incident reconstruction. It's in its 3rd edition now. And I'm also the author of a chapter in the Encyclopedia of Forensic Sciences on shooting incident reconstruction.
And how about, Mr. Haag, any forensic presentations of note?
I very regularly present both at conferences as well as for organizations on this area of work.
Can you tell us what certifications are offered in the area of firearms identification and comparison work?
The primary certifications, which certification applies to an individual and accreditation applies to a laboratory. So those are terms you'll often hear mixed. But certifications available and that are relevant to what I do include 3 from the Association of Firearm and Toolmark Examiners, 1 in gunshot residue and distance determination, 1 in firearm identification, that's the examination of microscopic tool marks, as well as tool mark identification, the examination of microscopic tool marks from other things besides guns, like screwdrivers and hammers and things like that. And then when the International Association for Identification had a certification, they've discontinued it, for crime scene reconstruction as a whole, I applied for and took that. All these tests involve both the knowledge test as well as a practical examination. And the AFTI ones, which are still active, of course, require recurrent training and testing.
Have you been recognized and testified as an expert before in a court of law?
I have.
Approximately how many times?
At last count, I think I'm getting close to 100.
And where have you so testified?
Primarily in the area where I worked for most of my 30 years in New Mexico, in Albuquerque. But in addition to that, all across the country, to include states like California and Texas and Rhode Island. And I'm not sure if I've been to Florida before, but many, many states across the country, and courts ranging from district or regional courts, state courts, to federal courts and military court martials.
Mr. Haig, have you given your opinions in high-profile cases before?
I have.
Give us an example.
The cases that come to mind would be Aaron Hernandez in Nation of Physical Evidence. It could involve the crime scene itself. It could involve trajectories. It could involve a wide variety of things within that sort of umbrella title. But I've taught a shooting incident reconstruction course for almost the entire last 25, 26 years of my career. They're week-long live fire shooting courses. So this isn't just a thought process. I go out and shoot things so that people that do what I do, crime scene investigators, forensic scientists, even pathologists, can come and see how these shootings take place and understand what they're looking at when they go into a scene. So I do that very regularly, especially now that I'm retired. I'm able to do about 4 to 8 of those a year, it seems like.
Is the assessment of bullet trajectories taught in your SIR courses?
It is.
Can you describe for us what a 3D laser scanner is?
This is a tool that I actually feel very lucky to have helped brought into the crime scene realm. It's an engineering tool, technically. But if you think of a laser rangefinder, a very simple one that you might aim at something, push the button, it shoots out a bullet of light. Light travels at a very consistent speed. So when that light is reflected back to the sensor, time is measured, and we then can calculate a distance because of that time and the known speed of the light. That's one bullet of light. A 3D laser scanner is an engineering tool that sits on a tripod and has such a thing inside of it, but spins in a 360-degree azimuth, left and right, and also is able to shoot out the laser beam in a vertical path as well. So imagine in this room shooting out millions of bullets of light and collecting individual data points on a very accurate scale, and then blending all those individual data points together. You get a representation of reality. You get a computer takeaway of your scene, and then you move that system from one place to the next. So you can move around corners, and you can blend all of these data sets together so that you really take the crime scene with you. So I was lucky enough with my police department to help start this theft of this technology into crime scene back in about 2005. And since then, many departments have also seen the value of it, particularly with trajectories, in my opinion. And it's become a very common tool across the country and internationally as well for crime scene investigation and shooting reconstruction.
Mr. Hay, can you define for us what exactly a trajectory is?
When I'm describing a trajectory, I like to think of it or describe it or liken it to a snapshot in time. If you imagine yourself in a dark room, completely dark, and things are moving, and you set off a strobe from a camera, let's say 3 times in that dark room while things are moving around, then you've really frozen things in place for that brief instant while the strobe was going off, or in our case, when a shot is going off, because bullets move to our perception of reality in a very fast manner, of course. And so if a bullet, say, goes through something and then strikes something else, it can help us orient those objects that are struck, and indeed then where the firearm is as well. So snapshot in time is how I tend to think of it, but it's a way of understanding where things were, including potentially the firearm itself, as well as objects that are struck.
All right, so you come upon an investigation, if you will, of a shooting incident and you reconstruct it, correct?
I try to.
All right, now would you tell us the significance, the importance of trajectory as it relates to that reconstruction?
In forensic science, you in very many ways have to throw out what you may have seen with regard to TV. Most of the things that TV puts out are completely false. But the beauty or interesting thing about trajectories with regard to shooting scenes is that fact that it gives us a way of assessing where things were in those moments of time. A person in my role may not be able to say exactly what happened in between them sometimes. Sometimes there's a logical progression of what might have happened given the physical evidence that we do have. But in my job, I basically lay the pieces of the puzzle on the table, meaning what physical evidence I have to look at from a shooting scene. And that can be the projectiles, the cartridge casings, the firearm itself, or trajectories, the room, and then try and see what snapshots in time we may have available to rebuild.
Is there a distinction between what you've been referring to as trajectory and wound path?
Wound path is sort of a subset of trajectory. Wound path refers to, indeed, just that, the path a bullet took or created when it goes through a body part in specific, or a body. But in each case, the accuracy and the meaning of those trajectories can be evaluated, because bullets, for the most part, there are exceptions, tend to travel in more or less straight paths. Like I said, there are absolutely exceptions to that, particularly with, we're not dealing with, in this case, non-expanding rifle bullets. But we look at these paths as relatively linear. Every measurement taken by human beings is an approximation, though. So an understanding of how much accuracy to place on those measurements and that documentation is absolutely, of course, important as well. With trajectories into things like walls, when I have good points to work with, or data from somebody's scan of a trajectory rod in place, for example, typically about plus or minus 5 degrees is what I've found from my work, and what I would call a industry standard in my work around a measured trajectory, around a straight line, if you will, that was created by something like a trajectory rod. With wound paths, it can be a little more difficult, and this is something I've lectured on to not only the pathologists in my area, who I worked closely and well with and helped train when they'd come in as fellows, and that I've lectured on at the Swiss Wound Ballistics Workshop 2 years ago, I think, and was asked to lecture on, is the idea that not only are trajectories in bodies a little bit more inaccurate because the way they're measured and how bodies move, we're not walls, we're not rigid. So we have to indeed look at those as a little bit more of an approximation. But for the most part, with things like we're looking at here, expanding handgun bullets, that category, we can describe them or think of them as relatively straight lines as documented. They give us an idea of where a firearm may have been at the time a shot was fired based on that path. So wound ballistics is a subset of just trajectory. They're related.
You may have alluded to this. If you did, my apologies. What is the degree of accuracy of trajectory reconstruction?
With regard to common things that I typically deal with in crime scenes, like walls, sheet metal in cars, desks, almost anything you can think of, I shoot in my classes to demonstrate this and basically check ourselves and see how accurate we are, about plus or minus 5 degrees. So I'm motioning with my hands to make sort of an arc. So if my primary line of measurement, we're going right down the center of my wedge here, I'm making a visual representation of approximately plus and minus 5 degrees, a 10-degree cone overall if you rotate that into 3 dimensions. But I think I can show you that later.
What steps did you take in preparation for your testimony here today?
When I do a case review such as this, there are materials that I typically would like to see in order to help inform myself on what evidence, what pieces of that puzzle are on the table to include, particularly documents, things like crime scene images, autopsy reports, lab reports, all the documentation that goes around a typical investigation, as well as 3D laser scan data, if it's available, amongst other things.
And in this case, did you examine all the evidence that was available to you?
I actually forgot to mention that. In addition to that, in this case, I did examine the actual physical evidence, meaning the projectiles, cartridge casings, etc.
And when you say projectiles, we're referring to the bullets.
Correct.
All right. And this information that was provided to you by the county, correct? By the sheriff's office crime scene?
Which information were you talking about?
That you were able to review in preparation for your testimony here today.
I think technically I received it through you, with the exception of the 3D laser scan data, meaning the documentation, the crime scene of photographs and autopsy reports.
Do you recall whether or not you actually came to the sheriff's office to do a review of the evidence?
Absolutely.
All right, let me ask you with that preface to tell us, please, about the projectiles in this case.
The examination of the projectiles helped me understand, in a way, where they'd been. This is sort of one of my main areas of interest, is the damage to projectiles. Sometimes, depending on their condition, when they finally come to rest, can tell us something about where they've been and what they've hit, especially if we're dealing with particular types of projectiles, such as we're dealing with in this case, which are expanding handgun bullets. This basically means that we're dealing with a construction that is designed to change shape if that projectile strikes something that is liquidy, and we are mostly liquid, so that would include tissue. A hollow point projectile is typically designed such that it has an external jacket made of copper. So my hands here are representing copper, and then that goes around it in 360-degree rotation. So in this demonstration, my finger's pointing up. That's the way the bullet would travel. A hollow point projectile has just indeed that, a hollow point cavity in the nose of the bullet. And it is designed that way such that if it's traveling stably, nose forward, and that hollow point cavity encounters something liquid, could be a gallon of milk sitting on a countertop, doesn't matter, or tissue. The liquid actually goes into that hollow point cavity, and because the bullet is traveling forward, you build up hydraulic pressure, liquid pressure, just like the brake lines in your car, inside that hollow point cavity. And so pressure inside that hollow point pushes the sides of the bullet open, and it comes open like this. So if I take my hands and make the model bigger for you, the jacketing material, the copper jacketing material that's facing forward as the bullet travels, when it encounters something liquid and expands, some people like the term mushroom, I don't prefer that term, but when it expands or encounters soft damage, the pressure builds up, and so that jacketing that was facing forward actually peels backwards, down and around, but it leaves you with a forward-facing area of the projectile that's greater than the original caliber. In mushrooms, you get greater surface area presented to the way it's going. And when you do that, you increase drag. And when you increase drag, you decelerate or slow that bullet down more quickly. And so these bullets undergo, or created through intense engineering by people at the companies, such that they go a preferred depth in tissue or tissue simulant. So the main reason for hollow points in handgun in particular, whether that's somebody in law enforcement or somebody interested in protecting themselves, as opposed to going to, say, the range, would be to control penetration depth. So this bullet will stay in one body, and you don't overpenetrate and go through further. When I work cases that have non-expanding bullets, often called full metal jackets, typically you can see overpenetration. You can go clean through one person and on into another. So that's the hollow point cavity mechanism.
Where were the bullets in this case, Mr. Haig, recovered?
From my review, there were 4 fired cartridge casings and 4 projectiles and 1 small lead fragment that were recovered. And we can kind of go through these because this brings into play a term called the limited universe, meaning we limit our options. We take pieces of that puzzle off the table and put them in their place. So for example, 1 bullet was recovered at autopsy. The entrance gunshot wound was listed as over here on the right chest, as I recall, and the bullet was recovered in the back of the decedent. That bullet, in my examination, shows soft damage, expansion, just as I would expect from bullets of this type. That bullet's wound path in the torso is well documented, and so we can kind of take one of four off the table in that the entrance hole, primarily for me in the shirt, is a nice round hole indicating that it was not unstable tumbling before it got there. This is basically a nice stable bullet entry, and that bullet was recovered there. So that's one of four. Another bullet was recovered after going through one of the walls of the bedroom and through several cabinets into a bathroom area. And under examination, when I looked at that bullet, it initially looked mushroomed, which is why I'm not a fan of that term, because it had the visual appearance of it, but it was just deformed. Instead of the jacketing material unfolding as I described before, how bullets do in tissue, it was just collapsed. So if you see pictures of this bullet, which as I recall, this is bullet number 11 in the crime scene images, I believe. While it looks fairly mushroomed, it does not demonstrate soft damage. And the hole going into the bedroom wall is again a nice round hole, indicating that that bullet was stable when it struck the wall, had not struck something else first. So that's two of our four bullets that are sort of off the table, and we kind of know somewhat what their story is. A third bullet was recovered down a hallway from the bedroom and in a wall. And other crime scene images indicate that it had gone through things like a book, I believe a part of a mattress, and maybe a book holder before it got to the wall where it was recovered. Examination of this bullet was very interesting in that it shows no signs of any sort of soft damage or even mushrooming of the nose. The nose is in its basically initial condition, but it has a very classic and typical characteristic to it that I demonstrate in my recon class when I ricochet bullets off materials at shallow angles. So when I say ricochet, I mean the bullet came in at a shallow angle and continued on along its path. It's a flat spot on the ogive is the part of the bullet we're going to talk about. It's the rounded part from the nose down towards what's called the bearing surface or the cylindrical portion of the bullet. So it's a big flat spot because things like tile, what we describe as unyielding surfaces, meaning they don't give, the bullet takes up the damage, create those flat spots. In addition to that, when you look at the flat spot, you see scratches or stria on it from dynamic interaction with the surface. And those lines go straight from the nose to the base. That tells me this bullet, when it struck tile, is the likely thing in this scenario, the floor, it was stable. It was going nose first to get that flat spot and be scratched directly from the nose to the base. It then continued on down range and was stuck in the wall. That bullet gives us some idea of some trajectory, even though it's stuck in a wall just barely. You can, in the crime scene images, see it stuck in the soft drywall because it's downrange from the bedroom where all of the fired cartridge casings, biological matter on the floor is, but that hallway gives us sort of a path, a trough that the bullet had to have passed through. There were no other documented impact sites in that area, so we have what's called ballistic accessibility. It creates a path into the bedroom area. If we assume that's where the firearm was, which is a logical assumption in my opinion, based on the cartridge casings, the biological material, that doesn't overlap with another trajectory. I'll come back to that in a second. Our fourth bullet is found on the floor in the bedroom, in the middle of the floor. Its position to me does not really mean much because it's laying there just on the floor where it could have been kicked, could have been moved slightly. So we don't know where else it might have struck in that room. But the key thing about this bullet, and this is bullet number 5, as I recall, is that it does show soft damage. It is expanded. In the images, you would see the jacketing material is peeled directly back and is facing rearward. The damage to this bullet tells me it went through tissue, something soft and liquidy, not things like wood and drywall or glass, but rather tissue. In this case is our limited universe option. So this bullet, number 5, would have had to have gone through the gunshot wound to the leg, which, as I recall, enters on the interior left portion of the leg and exits out to the right side of the leg itself. So those 4 bullets, and each one has a story to tell about what it did or did not strike.
When you speak of tissue, we're speaking about tissue of the human body.
I am.
Okay, just so we're clear. Now, did you bring with you today any slides or any type of diagrams that will assist you in your explanations?
I have two things that fit that bill. I have the Manatee County's 3D scan data with trajectories for one shot that I could show, as well as images I took of the 4 projectiles that I just mentioned that would help illustrate my points if you need me to.
All right. Before we get to that, let me just finish up the wound path. I'd like to ask you about the wound path to the shot in the chest. Are you able to say, based upon your training, experience, and education, whether or not that wound, where the shooter was relative to that wound?
Of course, I wasn't there for the autopsy, but experts rely on each other's reports in order to formulate opinions. The entrance is generally on the right, front side of the chest here. The bullets were covered in the back left area. Because bullets of this type, expanding handgun bullets, travel in relatively straight lines when they go into tissue. If you simply extrapolate those lines from the autopsy report, it gives you an idea of where the firearm was. I typically speak in terms of the firearm itself as opposed to a person. Of course, a firearm is just a machine, so it typically has an operator. So how that person is directly placed with the firearm is beyond my physical evidence examination ability. But the firearm, if you put a line straight back from where the bullet entered to where it went, it gives us our best approximation of where then a firearm would have been at the time that shot was fired. Again, that snapshot in time.
Are you able to reach any conclusion with respect to the order of the shots?
There's nothing in this from the physical evidence standpoint that allows me to sequence these shots 1 through 4. If one starts to make assumptions, which some people recoil at the word assumption, as long as you have a legitimate reason for saying the word assumption or are willing to describe its validity, we make assumptions in science all the time. It allows us to make further steps. So, for example, we have 2 trajectories through the body. We have 2 trajectories into objects into the crime scene. If I look at the trajectories just within the crime scene, one that has to go through that long hallway, and one that we actually do have some data for to figure out where the firearm was that just goes into the wall within the bedroom. And we look at those 2 trajectories, they don't overlap, meaning there's not a physical possibility for the firearm to have been stationary between just those 2 shots. I can't tell you with regard to sequencing which one was first, but if you make an assumption that the firearm, if you're the firearm, I mentioned right to left, moved from right to left, then the one down the hallway would have to have been before the one into the wall, if that's the hypothesis. If we take the opposite hypothesis, it's opposite left to right. That's where witness statements come into play to evaluate whether or not the physical evidence supports or refutes a witness statement. You never take a witness statement, and in my line of work, believe it. You look into what the physical evidence supports and then cross-compare them. So if you have information or an opinion or a statement that the firearm was indeed in motion from right to left, the physical evidence for those 2 trajectories would support that. As far as the body, for me, this case doesn't help too much because I focus more on the scene in this case. Others have focused on the body. But with regard to the scene itself, with the body itself, certainly we have an idea of where the firearm was relative to that body, but because those bullets don't then continue on to hit other things within the scene, I don't particularly have an opinion there that would lead me to allow me to then say sequence those in order.
Do you have an opinion as to whether or not the deceased was stationary or moving?
If we assume that the firearm was relatively stationary, and by that I don't mean a matter of 3 or 4 feet, I mean the firearm is not circling about the room, going out in the hallway of this incident or otherwise. If we take the position that the firearm is generally just in the bedroom and is pointed in the same relative direction as the 2 trajectories that I've described for you, then it would have to be that the decedent was in motion, because we have trajectories in the decedent's body that are almost opposing. We have one that goes from, as described in the autopsy report, and this is how it's commonly described in such things, front to back, right to left, and as I recall, relatively flat. I think it was maybe slightly downward, but I've forgotten the vertical component. But the key factor is that one goes this way, And as I read the autopsy report, the other gunshot wound enters the inside of the right leg and comes out the exterior outside of the right leg. These are basically two relatively opposing trajectories on an object that undeniably, in my work, objects, bodies regularly move in between shots for one reason or another. So given that, to me, those trajectories in the body indicate to me that the body was in motion.
All right, and with respect to the firearm itself, are you able to draw any conclusion whether or not that was in motion as well?
Certainly within the degree I've described before, with the two trajectories that I can show you, the one that goes in the wall, for those that I can demonstrate by physical evidence, there was some motion. And as I recall from my measurements in the 3D scan data, it's something like 4 or 5 feet, at least, from one position of one trajectory's area over into the area of the other. As an approximation, again, because again, trajectories are approximations. Otherwise, beyond that, no.
So would it be safe to say that your conclusions support the fact that both the deceased as well as Miss Benefield would have been moving from right to left?
I can't tell you that the firearm moved from right to left of those shots. A statement of such would be supported by those two trajectories that I mentioned.
All right, would you please demonstrate for us now from the slides that you brought how you reached the conclusions that you did?
Sure, it'll take me just a minute to set up the laptop.
Yes.
Yes, please, Your Honor. Thank you.
So basically what I'm getting from this is that Doug was moving, she was not. And, you know, when you think back on her testimony of the situation, basically she says, I showed him the gun and then he just was flailing in his body and he was inching toward me. And then, you know, he came at me and I shot. You know, not much more clarity than that. So now my question, I guess this diagram will help us understand a little better what this expert is thinking. But now what I want to know is, which way was the decedent moving? Was he moving toward the firearm or was he moving away from the firearm? And the thing that keeps getting me, okay, the thing that really keeps getting me is clearly Doug, the victim, was in a hallway. He was in a hallway, right? And she's in a bedroom. So how is he able to, what is the, he's in a confined, constricted space and she's in a completely different space with more room. He would have had to have been coming through with a freaking bulldozer to be able to really pose a threat. Those are the issues I'm having.
Please.
What I'm showing you here is the 3D scan data of the scene. So I didn't take this data. This was done by Manatee County investigators. I took the individual scan worlds and then blended them together. This is a process called registration. And I'll move you through it. Hopefully we don't get a jump between my laptop and what we see on the screen. So again, this is not a computer game. These are actually millions of individual data points. You can see in some of these places the individual spots. Each one of those is a data point collected by the scanner. And as we look down on the scene here, you're looking at the sort of wood-looking floor. You can see a tape on the floor. And now I'm going to switch perspective such that we're going to slide down to the side to allow you to get a feeling for what we're looking at. So as I move through this, you're now looking towards the doorway, exiting the bedroom over the top of the room.
Mr. Haig, I'm sorry to interrupt.
Please.
This is the room where the shooting took place.
That's my understanding. There are certainly fired cartridge casings, 4 of them in the room, as well as a bullet hole going into the wall here.
Okay, and that would be the mattress on the right-hand side that was leaning against the wall.
That's correct. Where I'm moving my hand cursor right here in the data is a mattress.
Okay. And are you able to, from that perspective, yet see the entrance to the room?
Yes, I can swing us around so that we look into the room even, if you wish. So as I come down in the data, I can put us in the doorway.
Okay.
So that's a view into the room, and we can then even come into the room in that manner and pan around and see the room. Within the room, as I mentioned, we have a perforation into the wall, a nice round hole. As I recall, this is impact site 11, maybe, but if I swing around here, I can actually show you where that is. So the shadows you're seeing on the wall here are from the tools the investigators use. These are very common tools in our industry, trajectory rods. For this type of scanner, they often put a sphere over that rod, so that's why you see a round shape there as well. But the main point here is that there is an impact site in the wall right here. That's where a bullet hole exists. From that, I took 2 different approaches to create this trajectory for visualization for you. One, I simply took the scanned data, basically their trajectory rod in place, and looked at the many, many data points on that and extrapolated a line from it. If we use that method, the trajectory for that looks like this. So this is the blue line that comes out of that. And I'll swing you directly above it so you can get what's called the azimuth viewpoint first. I'm going to click us back into what's called an orthogonal view. So looking at this trajectory, you see how as viewed, it has a slight left to right aspect to it, and it's traveling from the bottom of the screen as you're seeing it into the wall at the top of the screen. Now, the county investigators did a nice thing. They did 2 different ways with this trajectory, not only the trajectory rod itself, but they took the rod and then put a laser on one end and shined it across the room. So the bottom wall, as you're looking at it here, and measured where that dot was on the wall. So I simply took their data and connected the dots also. So between the perforation in the wall to their laser dot, and that line looks like that, so green and blue. In the trajectory world with walls, this is decent agreement between these 2 methods as far as the accuracy that we come to. And in fact, if I put plus or minus 5-degree cones, I talked about the error earlier, on both of these, we can see that those 2 cones look like that. That's actually a 10-degree cone for each of them, the green and the blue. And so from the data that I have for this case, for this one shot, I would include any area within that cone, either one of those cones, as the area where the firearm would have been at the time that shot was fired. I can also show you this from the side view to give you an idea of the vertical component. So I'm going to remove the left wall of the bedroom as you're looking at it here, and I'm going to swing you down. And from this vantage point, you can see how there is a downward component to these shots as well, going into that, I believe, again, number 11 hole within the bedroom.
Would that be consistent with Miss Benefield firing the weapon while she's standing in the upright position?
There are certainly multiple places along these cones where a shooter could be standing. So basically any hypothesis or any scenario that puts the gun in those cones, including that one, would be on the table. So we've seen the up and the down, the vertical component here. We've looked at the azimuth, the left and the right from above. What I'll demonstrate for you now with the data is I'm going to take you to the right.
If I may, Mr.
Please,
Hagan,
yeah.
As to that bullet, for the trajectory that you've just shown us, there was no indications that it had struck tissue. Is that correct?
That's correct. And I'll show you that picture of that bullet eventually. But this bullet, based on the damage that the bullet shows, as well as the nice round hole going into the wall, this is a miss of the decedent. This did not strike the decedent. If I take you to the side of the cone here, the far right side of the rightmost cone, our most right option, from that position directly over it, if you look down the hallway area, you actually, fill in, you actually cannot see where that bullet struck the wall. This area right here is to the right of the bullet's impact site. We actually have to move, as I will now, over into this area. And I'll get us right at the edge of the wall. We have to come all the way over here in order to get to the impact site, which from my examination of the images is more in this area. So somewhere on the tile in here is a bullet impact site, a ricochet off the floor. That bullet goes on and then barely perforates the drywall or penetrates the drywall up in this area. So,
And that's another bullet, is that correct?
correct. Sorry, I'm on to bullet 19, as I recall, was its designator for those two.
Let me recap for just a minute. So one goes in the wall, and then one goes down the hallway.
That's correct.
And again, you can't say which shot was first or second.
I don't have physical evidence that would allow me to establish that, correct? But that bullet in the wall down there also expresses no soft damage. It is also one that did not strike the decedent.
A miss.
A miss.
All right.
So from the 3D laser scan data, and I don't have a good trajectory or a good impact site to look at here. I was unable to go in and examine the floor. If I'd been able to find that impact site, I might have been able to refine that trajectory into the wall a little bit better and give us a more defined trajectory. But other than the ballistic accessibility aspect of going down that hallway, I can't do that here. Just they're two separate trajectories that have some slight divergence in the lateral aspect.
Did I ask you what the degree of accuracy is for trajectory reconstruction?
I think we covered that turf, just that plus or minus 5 degrees is an industry standard. And based on having shot a lot of stuff, including walls, for a trajectory like that, assuming the trajectory rod was placed properly, about plus or minus 5 degrees is appropriate.
Did you have an opportunity, Mr. Haig, in preparation for your responsibilities in this case to interview Ms. Benefield?
I wouldn't describe it as an interview by me. I was certainly present while she described the incident.
And with respect to her description of the incident, is there anything at all in your conclusions that was inconsistent with Ms. Benefield's description?
I can't think of anything that would necessarily be inconsistent. The key points that come to mind, where I remember her saying she stepped from her right to her left during the course of fire, that the decedent was moving rapidly in all sorts of patterns or manners, which would fit with the gunshot wounds entering the body in different angles. So from that perspective, no.
Give me just a moment, Your Honor, please.
Yes, sir.
I don't really remember her giving a very clear explanation of what actually happened. He basically demonstrated that he was like,
That's all, Your
arms
Honor.
around.
Thank you, Mr. Haig.
Cross.
I just have a couple of quick questions. So you were able to give opinions about where the trajectory would be for the two shots into the walls, correct?
That's correct.
But as for the injuries into the human, you cannot opine about that.
That's correct. I don't have any other sort of anchors to bring the decedent's body into play with the scene because of the lack of perforation.
Okay. And with reference to the chest wound, I saw you kind of turning it several times. So, and we've had terms used such as front and side. So if you could just show the jury, where was this entrance wound?
To the best of my recollection, and of course, I could refresh my memory with images if it's helpful, but to the best of my recollection, it's in this general area on the side of the chest, and then it goes in, is recovered just under the skin in the back. So if you're sort of the firearm location, it would place the upper body in a vague general orientation like this.
So if you turned your body
Straight.
This way?
right, can you keep turning until you get to the point where, okay. So that's approximately the positioning of the gun to the body.
For the upper body, yes, I'd have no way of,
That's a good
Correct, yeah.
demonstration.
Thank you, no further questions.
Redirect,
No, sir.
can this witness be released?
Yes.
Yes.
Sir, you're releasing your subpoena, you're free to go.
thanks, sir.
Thank you. It's gonna take you a minute to put that away, and it's about 10 minutes after 3, so I want to give you your afternoon break. Give you 10 minutes, go on back, stretch, get something to drink, maybe a little snack if you want it, and we'll get you back out here as soon as we can. Oh, no deliberations, don't talk with anybody about the case, and don't do any research. All right?
Okay. So what we're gonna do while they are out,
Figure that'd be better than having you.
Hustle.
what we're gonna do while they're out is review her testimony again of the incident. I don't think that defense witness really helped them that much. In fact, that last demonstration I'm going to show you again, that last demonstration that he did with the prosecutor kind of nailed it for me. She's like, okay, so if I'm pointing a gun at you, she basically is like, if I'm pointing a gun at you, tell me where the bullet would have had to have entered. Where he would have been turning for the bullet to enter where it did, and he does. And here,
Straight.
This way?
Right, can you keep turning until you get to the point where,
that's his demonstration. That is the defense witness's demonstration of where Doug's body was turned when he was hit.
okay. So that,
See? So as if she is holding the gun and he's the victim.
that's approximately the positioning of the gun to the body.
For the upper body, yes, I'd have no way of, correct, yeah.
I mean, to me, that says it all. That's the only testimony we needed from this guy. I mean, look, the defense has to get in all the testimony, all their experts. They have to do their very best to get the best testimony in for their client. I just don't think that helped them very well. So what we're going to do is I really have to go back and look, and I'm going to find it here. Go back. And look at when she testifies and tells the story herself. Here it is. All right.
Like moving around with his arms and his hands, and he starts inching forward towards me.
So he why do you call it a fighting?
He looks like a fighter, like a ninja or something. I don't know.
Okay.
The case of a former ballerina accused of perfect stage hid their daughter's birth from.
I just want to see that part. I was trying to find a video that
The doorway.
here.
His face.
As you're grabbing, singing you
I was scared. That side of my face is like swollen, and puffy, and discolored around my eye.
And is your eyelid drooping
Yes,
on the side where you were hit?
yes.
Your Honor,
He had never actually hit me before.
what did you do?
I ran
Where?
to my room
Why?
because I was scared.
Hey, Justice Jane, nice
Ashley,
to see you.
did you have anything in your room that could protect you?
I had my gun.
Did you grab the gun?
So they're on a break in the trial. They're on a 10-minute break, and they just had a ballistics expert, very, very good, he's a good witness just from the presentation perspective. He's, solid. He knows his stuff, all that stuff. But basically what he testified to was the gun was shot at a certain angle. It went from this angle to that angle. It didn't contradict any previous evidence that's been presented. And it didn't say specifically where she was to where he was. But at the end of the testimony during cross-examination, the prosecutor asked him to show how would Doug's body need to be turned where in relation to Ashley for it to go into his body that way. I feel for the jurors too, Justice Jane. I always feel for the jurors, of course. But anyway, and clearly he had to have been turning when she was shooting the gun, but she kept shooting the gun. She shot the gun 4 times and then it jammed, right? So during their break, I wanted to come back and look at her testimony and her telling the story of what happened. And I feel that it was a mistake to have her testify. Of course, I know that they really were painted into a corner and she had to testify because there were certain evidence that they needed to get in for their case. And the only way they could get it in was from her testifying. But I think she really, really, I think she really hurt herself in her own testimony because, what I wanted to hear was, and then I pulled out the gun and said, "Stop it." And he kept going and he lunged at me and so I shot him. We don't hear that. That's not what we hear. We hear he, did this and he was flailing and he inched toward me and then I shot. That's basically what we hear through hysterical tears. And so she's trying to convince us, I felt that she was trying harder to convince us of how she felt than of the actual incident and really failed.
Yes.
As you're grabbing the gun, what, if anything, did you hear?
I heard the door hitting the doorstop.
As if it is flung open?
Yes.
And what do you see, Ashley, when you look up?
Doug was standing in the doorway. His face was red. Like the veins were bulging in his neck. The way he was looking at me, it didn't even look like Doug. His eyes were black.
Does he yell anything at you?
He said, "You're done."
What does he do at that point?
I held the gun like in front of me and I said, "Stop." And he turned and he got into this like a fighting stance.
So I feel like that's where she's trying to compensate for where the bullet ended up in his body. Because she says he turned and he got into a fighting stance. He turned and he got into a fighting stance. But we need to hear at this point is he lunged at me, he came at me, he was running at me, those types of things. We don't hear that.
Yeah, like I got low and he started like moving his arms and his hands around. He was making these like jerking motions.
What were you expecting?
And everything she's saying is consistent with somebody who's probably having a complete freak out, right? He's probably freaking out. He's like screaming and yelling, and his arms are waving as part of this fight and freak out. And we're not hearing how she's responding, right? We're not hearing that she's yelling or screaming or doing anything to, escalate the situation. She clearly isn't de-escalating by taking out a gun, right?
When you were holding the gun out in front of you and you told him to stop?
I thought when he saw it, he would leave.
Did he?
No.
So she thought that, okay, I'm going to pull out the gun and point it at him and he's going to leave. And so basically she's saying, I pointed the gun at him and he didn't leave. Okay. So is not leaving a reason to shoot him? It is not leaving a good reason to shoot. That's my question.
Oh.
At that point, Ashley, what are you thinking?
I thought he was going to kill me.
Now,
tell us what happens next.
He started.
So she thought, here's the big question here. This person on the stand says, I thought he was going to kill me. Is that what a reasonable person would think? Is she being reasonable in this situation? Because that's usually the standard for, in court for making a determination about what people do. In the description, even as she's describing the situation, well, he turned and he got into a fighting stance and I thought he was going to kill me. But what was he doing that said he was going to kill you? Did he say, I'm going to kill you? He said, you're done. That could mean anything, right? Right. And that's the other thing. Let's keep in mind, she's the one holding the gun. So, and he's, ostensibly not. So did she think that just pulling out the gun and showing it to him would make him just turn and run? And that's basically what she's saying. I pulled out the gun, he didn't turn and run, so I shot him. Yeah, exactly, Patricia.
Coming towards me, and then he lunged at me, and I started pulling the trigger.
He lunged at you.
And he just kept coming. And I remember trying to move.
So now she does say, he lunged at me and I started pulling the trigger. If he was lunging, would it have gone into the side, into his side? If when someone's lunging, now that there's a possibility, but I'm not quite believing her take on things because she's not convincing me.
I had to get away from him, but he kept coming at me.
Ashley, would you tell us why, if you're holding a loaded firearm, you were attempting to move away?
I was trying to get away from him. I was terrified.
All right, so
They're back in court. So,
Good afternoon, Doctor. My name is Judge White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone, just to get a loud, clear voice. It does adjust up, down, left, right if you need it.
Yes, thank you, Your Honor.
good afternoon.
Good afternoon.
Would you tell us your full name and spell your last name, please?
Yes, my name is Emma Lew, L-E-W.
And do you hold any professional degrees?
Yes, I am a licensed physician in the state of Florida, so I have an MD degree.
All right, Dr. Liu. Let's take a moment. Let me just run you through your undergraduate education. Where
Yes.
did you receive that?
I graduated from the University of Saskatchewan College of Medicine in Saskatoon, Saskatchewan, Canada.
And following your college degree, you attended professional school?
I did a one-year rotating internship in Vancouver, British Columbia, and started my pathology training in Vancouver. I completed my pathology training in Saskatoon, Saskatchewan, worked for 3 years as a staff pathologist at the Royal University Hospital, then came down to Miami in July of 1991.
And with respect to your work experience, what brought you to Miami-Dade County, Dr. Liu?
I wanted to train in the best facility that there was for forensic pathology, and everyone in Canada and in the States said, go to Joe Davis in Miami. So I did.
And did you eventually rise to the position of the medical examiner for Miami-Dade County?
Yes, when I was in training, I was an associate medical examiner. Then Dr. Davis offered me a permanent staff position, and I was an associate for 10 years.
I want to ask you if you can tell us, if you can approximate the number of autopsies that you've performed.
In Miami-Dade County, it should be at least 5,000.
As part of your duties as a medical examiner in Miami-Dade County, Dr. Liu, did you also respond to crime scenes?
Yes, we responded to scenes of violent and suspicious deaths.
Would you tell us why? Well, first, let me ask, is it typical for the pathologist to respond to crime scenes? And depending on that issue, why you chose to do so?
Yes, in Miami-Dade County, when law enforcement needed a medical opinion, whoever was on call as the medical examiner would respond. And the purpose is twofold. Number one, so that we can provide an opinion about the circumstances of death or the types of injuries on the body, and also for our benefit, so that I can see, or we can see, the body in the context of its surroundings and be able to better interpret our findings at the time of autopsy.
Do you teach any courses?
Yes, I used to teach in the medical examiner death investigation course, and I still teach for the Carnival Cruise Lines security conference, and I will be lecturing in the Miami-Dade Police Homicide Investigations course.
And how about gunshot wounds? Have you taught courses in gunshot wounds?
Not entire courses, but I have taught the section about gunshot wounds in death investigation courses.
Let's not take anything for granted. If you'd be kind enough, would you explain to us, Dr. Liu, what is an autopsy?
An autopsy is the examination of a dead body. It consists of two parts. One we call the external examination, and that's when we look at the outside of the body and describe such things as height, weight, color of hair, eyes, scars, tattoos, any evidence of medical intervention, that is, any evidence that paramedics or doctors and nurses may have treated the decedent, and then any evidence of injury. After looking at the outside of the body, both front and back, and in the orifices, then we do the internal examination. And that's when we open up the body cavities to examine all of the organs and tissues inside the body cavities, from the brain inside the head down to the pelvic organs. That is an autopsy.
Dr. Liu, were you asked to assist in this case?
I believe I was, yes.
Would you tell us how?
I believe you contacted me.
And what did you do in preparation for your testimony here today?
I reviewed the autopsy report. I reviewed some of the autopsy photographs, and then other circumstantial evidence, as well as having spoken also with Mrs. Benefield.
Okay, I need you to try to keep your voice up. Did that include being present for Miss Benefield explaining what had happened?
Yes, I had made a previous trip to Bradenton and had met with Mrs. Benefield.
I'd like to ask you, Dr. Liu, about the gunshot wounds in this case.
Yes.
Will you tell us how many there were?
There were 3 separate gunshot wounds.
And would you please explain them?
Yes. One was a superficial gunshot wound on the right upper arm. And that we call a grazed gunshot wound. That was one of the gunshot wounds. Shall I explain the direction?
Please.
Now, you probably heard about pathways of gunshot wounds from Dr. Vega. But as a quick refresher, if, for example, a gunshot wound was from front to back and right to left, that is relative to the person shot, not to you, not to Mr. Taylor, but relative to the person shot. So if it's from front to back and right to left, it is coming in from the victim's front towards the back and from his right side towards his left side.
And was there another gunshot wound?
Yes, there was another gunshot wound on the right side of the chest, just outside of the right nipple.
Please do.
And yes, the pathway of that gunshot wound happened to be from front to back and right to left. And I'm sure Dr. Vega told you it just nicked the bottom of the right 5th rib, went through the right lower lobe of lung, then through the part of the spine, the bone of the spine, then the left lower lobe of lung, and then nicked the back of the left 10th rib.
And lastly, was there a third gunshot wound?
Yes, there was a gunshot wound. This time it was a through and through gunshot wound, or what we call a perforating gunshot wound, that entered the inside back of the right thigh, went through both right lower leg bones, and came out the outside of the right lower leg just below the knee. And that pathway was from back to front, left to right, and upward through the right lower leg.
Let me, if I may, using the easel, show you a picture. And have you explain to the ladies and gentlemen of the jury, you mentioned that the abrasion wound to the arm, did you tell us what the trajectory was for that?
In my opinion, the pathway of that bullet was from front to back, upward, and slightly left to right.
Okay. So how, Dr. Liu, are you able to reach a decision like that on something like an abrasion wound?
Through experience and training, having had hundreds of gunshot wound cases and seen thousands of gunshot wounds and supervised hundreds more cases.
Okay, let me show you these two demonstrative aids and ask, with court's permission, if Dr. Lou could step down. I wonder if we could have the easel so I could set these up. Dr. Lou, here is a pointer that will help you.
State, feel free to reposition as you need so you can see what's going on.
Thank you, Judge.
With the court's permission,
Yes,
I
ma'am, you
ask
can step
Dr.
down.
Lou to
Thank
step
you.
down.
State, have you already seen these?
Yes. Not until now, but I just saw them.
Okay.
You have a preference of which one you'd like to start with? Okay, with this one. All right, would you tell us what that represents, Dr. Lou?
This is the graze or superficial gunshot wound on the outside of the right upper arm. I know there's a
Yes, a rod.
point that will not
We have three.
Now, the reason I know that this is a graze gunshot wound is, from training and experience. Now, the direction of this projectile. You see, this edge is a little bit more rounded, and because it's a deeper red, I know it's a deeper part of the wound than here, for example. Now, as the projectile skips across the skin, because it's so superficial, it raises skin, it causes skin tears and raises skin tags. Now, there's some skin tags here, but the best one is this one right here. See this V-shaped tag? And for simplicity, how I remember pathways of graze wounds is that the skin tags point toward the gun. So, if it's pointing in this direction, the gun is somewhere along this line here. So the bullet, therefore, is coming in this direction, going from front to back. This is the front, this is the back. Going from front to back and upward. And because it's on this part of the line, you can see it's slightly to my left, to my right. So this is from front to back, upward, and slightly left to right.
If I may.
This is the gunshot wound that we just spoke about. You can see how it's going front to back and upward. This is the right nipple. This is the second gunshot wound. But it's been a bit changed or altered because the back portion that's straight was an incision made by the doctors in hospital. So the gunshot wound itself is this round part. Now this is the one that goes from front to back and right to left. The bullet was found by Dr. Vega on the left side of the back. Now, there's something special about this gunshot wound that Dr. Vega may have told you already. After going through the nicking the right fifth rib and the right lower lobe of the lung, it then hits the spine. Now, the skull closely surrounds the brain and protects the delicate brain. The spinal cord is an extension of the brain, and the spinal cord is protected by the spine, which is made up of multiple blocks of bone. When a projectile cuts across the bone of the spine, even though it doesn't touch the spinal cord. The energy that is expended by the bullet impacting the bone is transmitted to the delicate spinal cord. And what this bone will do, because the bullet went across the bone of the T10 vertebrae, it causes a spinal cord shock. And the result is paralysis of the legs. I know because I've had cases like this where a bullet not even going through the bone of the spine, just passes by the side of the spine, caused the man to fall on his back, and he was heard to say, "I can't feel my legs." So that's something that's significant and important about this gunshot.
All right. I think you can probably return to your seat if you like. Does it have some water in it?
It does. It's too complex for me.
Let me see if I can help.
Not too much. It's neat. Probably the right orientation.
Dr. Liu, did you have an opportunity prior to your testifying here today to meet and observe and listen to Miss Benefield explain the events that took place on that day?
Yes, I did. It may have been last year that I did that.
Is there anything at all with respect to your findings that is inconsistent with the explanation Miss Benefield gave?
I believe that Mrs. Benefield's account is consistent with the evidence on the body, and I can demonstrate that.
At the time that you observed Miss Benefield explain these events, did she know what the actual physical evidence was, the actual
Objection.
forensic
Hearsay, Judge.
evidence?
If she can answer without speculating.
I do not know. However, usually the person doing the shooting does not know about the autopsy results. And even if they got the autopsy report, they would need someone to translate the autopsy report for them. So I doubt it, but I am speculating.
Were you struck by the explanation you received in light of that?
Objection relevance.
I'll sustain.
One last question, Dr. Liu, if I may. How many times, if you can approximate, have you appeared as an expert pathologist and testified in court?
During my career, at least 500 times, and then maybe 20 some times more after I retired.
And the vast majority of those occasions, did you testify for the defense or for the state?
Most of those times I testified for our state attorney.
I have nothing further, Dr. Liu. Give me just a moment, Your Honor. Yeah. Dr. Liu, would it be helpful if I were to volunteer my law clerk to come up and allow you to show with the trajectory rods the wounds that were sustained by the deceased?
I believe it would add a new dimension to my testimony. Yes.
Okay. Judge, with your permission, may I?
Yes.
Come on up, Will.
May I step down, Your Honor?
Yes, ma'am, please do.
May Dr. Lou step down?
Now, I believe that the Gray's gunshot wound was the first gunshot wound because Ms. Benefield indicated that Mr. Benefield was coming towards her. Objection, Judge.
I'm going to sustain.
Go ahead, Dr. Lou. You just can't say what Ms. Benefield told you,
Okay.
just based upon your conclusions.
I believe the first gunshot wound.
And I would object to that opinion, Judge.
I'm going to need you to approach, please.
Yeah, he's starting this witness is starting to get into the order of the gunshot wounds and what, when they happened in sequence, and how can she come to those conclusions unless she is basing that on what Ashley said. This defense attorney, he does whatever he can to get the testimony that he wants in.
Dr. Lou, without regard to anything that Ms. Benefield may have said that you heard, based upon your expertise and your own conclusions that you reached, do you have an opinion as to which one of these shots may have been fired first?
I believe that the right upper arm raised gunshot wound was the first shot.
Are you able to say why, what independent evidence exists that leads you to that conclusion?
I have based my opinions on the circumstances provided to me.
Okay. And would that be consistent, the upper right arm wound, would it be consistent with the bullet that went down the hall, for example, and lodged in a book?
Yes, it would be, because it didn't go into the body, it just went across the skin. So the bullet would be free to continue on into another room.
Okay, and because it is just a graze, it would not have any tissue effect or mushrooming, as they say, correct?
Objection.
If she can testify to that from her knowledge and experience.
Because it only grazed the skin, nothing went into the hollow point nose of the projectile to cause deformity or mushrooming of the projectile. So it would be more or less pristine.
All right. Now, you've told us, Dr. Lou, about the shock to the spinal cord from the shot that entered the chest.
Yes, going from front to back and right to left.
Would that have, in your opinion, affected Mr. Benefield's ability to stand?
Yes, as I explained earlier, it would cause a spinal cord shock, causing paralysis of the legs and causing Mr. Benefield to fall.
And in falling, would it be consistent that his legs would go up in the air almost as if he slipped on a banana peel?
Yes, that would be consistent, and I can demonstrate.
Please.
Really?
With the right side facing the judge.
Judge, with the court's permission, could the jurors perhaps stand so that they could see this demonstration?
With the right side facing.
Judge, I'm confused as to what we're demonstrating.
We're demonstrating the shot to the leg.
Oh, the shot to the leg.
Yes, sir.
Okay, folks, if you need to stand or reposition yourself.
But the doctor is not a
Now,
not
the
reconstructionist.
entrance was on the right side of the entrance was on the right side of the back of the cab. And the exit was here. Now, you can see
Oh,
that the gun would be somewhere along here. So you can see how consistent this pathway would be from getting shot while he's on the ground with the gun being in this position. So it's going in here and coming out here.
Okay, so this would be, in effect, a snapshot in time.
Yes, it happens very quickly.
All right. And would it be consistent, Dr. Liu, with the shot to the chest, paralysis, Mr. Benefield falling backwards, his legs going up in the air, and another shot going through the leg?
Yes.
All right.
How can his legs go up in the air if they're
So
paralyzed?
consensual is consistent with that.
All right, thank you very much. Thank you, Will. I have one last question for you, Dr.
I hope
Liu.
that's asked on cross.
You can take the witness stand. Do you recall whether there was any other injury to Mr. Benefield that would be consistent with his legs going up in the air and him falling backwards so that his head would hit a tile floor?
Yes, Dr. Vega found an abraded contusion on the back of the head. A contusion is a bruise. An abraded contusion means that there's a little bit of scraping of the skin or crushing of the skin in the center of that bruise. That is entirely consistent with Mr. Benefield's back of the head striking either the wall or the floor as he fell on his back.
Thank you very much, Dr. Liu. I have no further questions, Your Honor.
Cross.
I just want to ask you about the leg wound
Yes.
for a moment. You're not saying that that is the only position that he could have been in, are
No,
you?
I am not saying that.
Okay, so there are other positions that maybe could have produced that wound path.
Yes.
Okay. The one that you are describing is just one that is consistent with it.
That is correct.
And when you said his spinal cord would be, I don't know what you said, shocked, maybe?
Yes.
Concussed? I don't know what you said. And his legs would go paralyzed.
Yes.
Does that normally mean that they stiffen, they straighten? Does it mean they crumble? What does it mean?
Different people react differently depending on the position that they're in. And paralysis usually means just not being able to move.
Okay. So depending on maybe what movement they're doing at the time, that's what they're going to continue to do.
Possibly,
So,
yes.
So if he is walking towards someone, we fall backwards with paralyzed legs?
Well, we weren't there, so I don't know exactly his body positioning and movements.
Okay. All right. And you spoke about the abraded contusion on the head, and that can be consistent with falling.
Yes.
From a gunshot. Can it also be consistent with being drug out of the house by EMTs?
Not unless that part of the head would be struck on something, because the contusion is a bruise which requires blunt force.
Right. So if, for instance, he was being drug out and hit the door jamb or something, bounced his head, could it have caused that kind of a braided contusion on the head?
Well, done with enough force, that is possible.
Okay. Thank you. No further questions.
Direct.
One. Dr. Lou, would the abrasion wound to the right arm of Mr. Benefield be consistent with him lunging towards Miss Benefield?
Remember, the pathway is from front to back and upward. So if he was lunging and you were the shooter, you can see how that would be consistent.
That's all. Thank you.
Do you have any questions on that?
No.
All right, can this witness be released? Can the witness be released?
Yes, sir.
State? Ma'am, you're released from your subpoena. You're free to go.
Thank you, Your Honor.
Thank you very much. Mr. Taylor?
We have this one issue left.
Okay. All right, members of the jury, there's a legal argument I need to take up. If you could step out for about 10 minutes for me, we'll do that, then we'll bring you right back. No deliberations, no communicating with anybody about what we've talked about the case, and don't do any research on any of the issues.
So the rumor on Twitter is that was the defense's last witness. And the other rumor I'm seeing on Twitter is that the state wants to sanction the defense attorneys. I don't know if that's what they're about to take up here. Usually that happens after both sides have rested, but we'll see. We'll see what. I think this is one of the many things they've been waiting to talk about.
And I have the following case for the court.
See, the jury's out. And was this the issue, the Richardson?
No, this is the DNA issue.
Oh, yes.
So that's another thing I was confused about is this last witness, Dr. Liu, said that the bullet was going upward, but the last expert testified and demonstrated that the bullet, at least one of the bullets being shot, they were going downward. And I don't know if they were talking about the same shots and the same bullets and whatever, but the point being that it's extremely confusing testimony. The jury has to be confused. It'd sure be nice to know what their plans are here. Like, what are we waiting for? Are we waiting for a DNA expert or something? Yeah, Patricia, there must be some. I'm sure if we thought, even in our own memory banks, thought long enough, we could think of a situation when there was real self-defense in a shooting situation, and we could compare. And because, again, to me, yes, the cumulative emotional abuse factors into all of it, and how it factored into the, her frame of mind during the situation and her decisions and all that stuff. But I don't think a reasonable person, given what we know about their relationship, I don't think a reasonable person would assume that a guy standing in a doorway, raging mad, is a dangerous threat, especially when she's the one holding the gun. Yeah, and the legs flying up in the air when he fell. There's just no explanation. There's no. And the other interesting thing is that the bullet went into the bullet that went into his leg went in a different trajectory, basically. Yep, that's true, Tiggy. Not only is it all her story, it's that all her story isn't super convincing. When you go through her telling her story, let's go back to it, because we were just checking it out. We were just watching it, and we'll come back to this when they come back on. I'm listening. I'll be watching and listening. But her story just doesn't hold up.
You're firing. He keeps advancing. What happens next?
It was like his feet slipped out from under him and his legs went up in the air.
When Doug hits the floor, what's your immediate reaction?
I ran to get help. It was like his feet slipped out from under him and his legs went up in the air.
His feet. Hi, Terry Bass. His feet slipped out from under him and they went up in the air.
When Doug hits the floor, what's your immediate reaction?
I ran to get help.
And her immediate reaction is to run and get help, not call 911. It's to run to the neighbor's house and say, I've been attacked and I shot the man in self-defense and he's laying there. She knows that when you've shot somebody, time is of the essence. If you don't want them to die, time is of the essence. And she runs next door to get help. Y'all, these are all the things that are getting to me, you know? It's really boils down to this incident. If I was convinced that he had been, if I've seen a lot more evidence of his behavior toward her, a lot more evidence of his menacing behavior toward her, I'd be more convinced. Oh my gosh, Terry. Yeah. What is the logic in running to some other place? It's like being so first of all, it just says you're a helpless person. You're absolutely completely not self-contained person. Is that her teaching to her daughter? Is her teaching to her daughter, hey, after you've shot somebody in self-defense, run next door for help. Don't call 911 immediately. Just run next door for help. What if the next door neighbor wasn't home? What if he wasn't home? All right, they're talking now.
Wanted to introduce it, but then changed their mind because it didn't have any inculpatory conclusions for purposes of the defendant. At that point, the defense moved to introduce it because it was exculpatory. The court allowed the admissibility as a business record, distinguishing it from Crawford because since it was the defense that was seeking to admit it, the confrontation issue was not essential. And on appeal, the appellate court sustained that admission under the business record exception, which is precisely what the circumstances are here, Your Honor. So I can't imagine that the state is going to, and I would further say to the court, the chain of custody is irrelevant. We're not objecting to the chain of custody. I can't imagine that the state would object to their own chain of custody. So we think that the Shorter case clearly establishes that the court can admit that DNA profile, the results, as a business record.
Judge, I thought I made it abundantly clear. I'm not objecting to it being a business record certification. That's what I said 6 times. My objection is that there has been no foundation laid to then make that report relevant. That is hearsay in the report. The fact that those swabs are identified to Ashley Benefield or Doug Benefield is hearsay to DNA labs. That means some crime scene tech who did not testify before this jury went and collected his DNA stain card. A different crime scene tech who testified she swabbed her but was not shown swabs to make sure those are the correct swabs, then swabbed her and put those in proper evidence. That's all. We don't have any evidence that the same swabs that she was collected then went to DNA labs. And that's what you have to lay the proper foundation. And this is the case I was referring to when I didn't refer to it by name, but this is what I read when I made my objections, because my objections are what I've already stated, but also 403, just that lab report in evidence. This is very confusing. It's DNA, and it's overly prejudicial to this jury for what I think what it says is this state didn't argue, and I am arguing, how the forensic casework would be unfairly prejudicial or confusing in regards to the work of the jury. This is DNA. I don't know, they sent us the bench notes and the report, but there's no explanation of the statistics, how they came upon those statistics, where those swabs came from, all those things, and I think that will be very confusing to the jury without somebody here. So I'm not making a certified business records objection. I'm making an objection to the contents, and that there hasn't been an adequate foundation, and that they're confusing.
Sure.
Yeah, so the court recalls that Detective Warren sent the swabs to the lab. Megan Dorvac testified that she swabbed Ms. Benefield, I asked her why. She said because it would show who had touched her. The court should recall, consult your notes, Your Honor. Ms. Benefield testified that Douglas Benefield grabbed her by the hand and spun her around as she tried to leave the house. This report corroborates that to the extent of, I think, 720,000 times more likely. We think it's an essential component of our defense. Now, we don't have any. Chain of custody is irrelevant. Even though they've just basically undermined their own chain of custody, it's not an issue. It's the result that for our purposes and our defense is essential, Your Honor. This case allowed it to be admitted as a business record. The assistant has made eminently clear that that is not why she's challenging it as a business record. I don't seek to introduce the entire report. I will be quite happy reading these two sentences, if I may.
Thank you, because I haven't seen this. Thank you. All right, final thoughts? Is that everything?
Yes, sir.
This is, what I've been handed is not marked as an exhibit. It's a 5-page document from DNA Labs International. It actually, it's a letter or a report to Detective Justin Warren and a sergeant at the Manatee County Sheriff's Office. And it is signed by Jerome Rem, R-E-M-M, forensic DNA analyst. It lists a number of items. $14 different items that were apparently sent to DNA labs for DNA testing. And the particular section the defense says they want to admit is agency item number MRD5, which would correspond to DNA Labs International item 20-10880, swab from suspect's right hand. And it says that the testing was done. Mixture of 2 individuals, at least 1 male contributor. And it says Doug Benefield and John Sant could not be ruled out as possible contributors to this foreign DNA profile. And it gives, based on its testing, 2 different propositions that were considered to explain the results. One is the DNA profile obtained from the swabs is 720,000 times more probable if the sample originated from Ashley Benefield, Doug Benefield, and 2 unknown persons than if it originated from Ashley Benefield and 3 unknown persons. So there's strong support that Ashley Benefield, Doug Benefield, and 2 unknown persons contributed to the profile rather than Ashley Benefield and 3 unknown persons.
So no one has to read that next sentence.
I am. I'm reading it as I go.
Okay, thanks, sir.
If applicable to the case, it is recommended that reference standards from any first-degree relatives of Doug Benefield be submitted for additional comparisons. And I think this is the second proposition that DNA Labs is considering. The DNA lab profile obtained from the swabs is approximately 75 million times more probable if the sample originated from Ashley Benefield and 3 unknown persons than if it originated from Ashley Benefield, John Sant, and 2 unknown persons. Therefore, there is extremely strong support that Ashley Benefield and 3 unknown persons contributed to this DNA profile rather than Ashley Benefield, John Sant, and 2 unknown persons. The DNA profiles of additional contributors to the mixture were not determined. However, there's results that are suitable for comparison. All right, so obviously those of us who have done a number of these cases understand what those statistics mean when you're looking at known standards versus unknown DNA samples or swabs and the comparisons. I am not sure, and I do not have the belief that the interpretation of DNA results as outlined in this DNA Labs report is within the common knowledge of a lay juror, a regular juror. That's why the standard we usually see is one of the parties, whoever it is, whoever the proponent of the evidence is, calling the DNA analyst, generally after showing and evincing whoever took the sample, packaged it, where it was stored. It was then sent from the property and evidence room to the DNA lab. Then the DNA lab analyst will say how they went and got it. And I'm just going to disagree that chain of custody is not important. That's why we have it, and that's why we have certain predicates to establish evidence from a crime scene to court and who touched it and how it changed and what was done to it. So I disagree that that's not important.
Isn't that when the defense contests?
In the problem, well, I gave everybody the chance to argue.
Sorry.
So I got a chance to read the shorter case, and the shorter case supports what the court is saying. It says that they leave the issue for another day, whether it could qualify as a business record. However, there remains, and this is at 692 of the decision. However, there remains a very significant section 90.403 concern about the admissibility of a DNA forensic report if the expert preparing the report does not testify. And the reason the fourth DCA, it says so in the very next paragraph, the reason the fourth DCA upheld the admission was for that very reason, that the state did not argue 403. And here they are. Here the state has argued the 403 for a jury to understand what these mean, what these findings mean. I don't find that the probative value is, I do find the probative value is substantially outweighed by the danger of the confusion of the issues, the misleading of the jury to try and understand what this report says, and be subject to cross-examination from, well, this time it'd be the state, but it's usually the defense, to explain, where do you get this? How do you get 720,000 times? How many loci were matched? How did you conduct these evaluations? And then what does it mean, the very strong support?
That is,
And then it's also, you've got, the other problem is, Mr. Taylor, you're telling me you only want to read this, you said 2 sentences. Yeah, these 2 sentences that are highlighted.
correct.
But that's only one of the 2 sets of propositions that could potentially explain this. And the first proposition you want to use doesn't even mention Mr. Sant. And if I'm reading this correctly, there's also a recommendation that there should be some additional testing. There's also additional DNA profiles that are in these mixtures from Ms. Benefield's right hand that are suitable for comparison and have not been compared. So, I mean, I have significant concerns about the misleading of the jury by putting this in.
Can I make my record?
It would, if it would,
So according to this tweet, which of course I can't validate, but according to this tweet, the guy that they just used in that demonstration earlier with the other medical examiner was Ashley's fiance. That was her actual fiance that they used in that demonstration. Okie dokie.
one of the propositions that was considered by DNA labs in interpreting their test results, certainly that would be even more misleading because it doesn't get into the other proposition and the other testing that needs to be done. So based upon that, do you want to have this marked and put into evidence?
Yes.
As a proffer?
I'd like to proffer for the record, Your Honor.
Do you want to put a number on it? What's your next number?
It's 29, but this is the whole record.
Well, hold on. You're handing me a stack of paper that's about, what, 1.5 inches tall?
Yes.
And the only thing you said you were going to enter was this 5-page.
Well, no, I said the only thing I wanted to enter was to read those 2 sentences. This is the full report.
All right. So it would be your intention to admit into evidence Defendant's Exhibit 29. What is this in here? Or does this go in here?
Yeah, no, that I believe is in there.
No, it goes.
This comes back. Oh, I'm sorry, Your Honor, I stand corrected. This goes in with the report.
I'll let you put it where you want it.
All right. Can I make a proffer for the record?
Yes, absolutely.
All right, thank you.
Oh, wait, beyond, I thought you already did. This is the proffer.
Well, I'd like to make a verbal proffer as to precisely why I think it should be admissible.
Yes, sir.
Okay, so unlike a DNA report that's inculpatory, which requires a chain of custody so that justice is established in the admission of inculpatory evidence, in this instance, Judge, we believe this DNA report is exculpatory. And we believe it's exculpatory because it confirms Miss Benefield's testimony that Doug grabbed her by the hand and spun her around as she tried to flee. It's independent evidence that not only corroborates Miss Benefield's testimony, but also corroborates our defense. And because it is exculpatory, chain of custody is irrelevant. We are making no objections to chain of custody. The case law that I submitted to the court, the shorter case, clearly would allow it. And it would be my intention, which I don't think is confusing at all to the jury, to tell them the DNA, reading from the report, the DNA profile obtained from the swabs is approximately 720,000 times more probable if the sample originated from Ashley Benefield, Douglas Benefield, and 2 unknown persons than if it originated from Ashley Benefield and 3 unknown persons. Now, maybe I misunderstand this, Your Honor, but to me, what that says is there's 720,000 times more probable that Doug Benefield touched Ashley Benefield's hand. That's what I believe this says, and that's what I think we should be entitled to get to the jury.
Thank you. Do you want that right after the first page?
You put it right on top, Your Honor.
It'll cover up the exhibit number then.
Oh.
So when you're trying to get in DNA evidence that a hand was touched, and you're trying to say that a hand being touched or grabbed is justification for deadly force of self-defense, as a jury member, a public opinion jury member, I wouldn't buy that.
Confusion and misleading. So that's the basis of my ruling.
What if I told the court that the actual DNA lab expert is available, but not until after 2 tomorrow? And it would have to be by Zoom.
There's motions that Florida Rule of Criminal Procedure 3.116 defines how and when that can happen. So we need to bring the jury back in, and I just need to know if your intention is to call more witnesses or if you're resting.
Well, I make a formal request that the court abate the proceedings so that we could call the analysis. If the court denies that, then we will rest.
All right. Well, there's Florida Rule of Criminal Procedure 3.116 is very specific. It just came into effect. It was just substantially, amended effective July 1st of this year regarding the use of remote technology. If you want some time to look at that, I can certainly give you that.
I'm familiar with it.
Mm-hmm.
Press.
Okay, let me bring the jury in. I will, we can do that, then I can let them go for the evening. I'll tell them to be back tomorrow morning at 8:45, just like we've been doing with the 9 o'clock start.
Yes, sir.
Just so you know also, we had submitted, the court may recall, you requested copies of the proposed homicide charge. And we had submitted our version to you that we thought would be appropriate. And I did not save a copy of it, so I want the court has it.
I will have to look. Did you send it by email?
No, I believe we handed it to Your Honor.
All right. Welcome back, everybody. Y'all can have a seat. All right, anybody in deliberations, talk with anybody outside the jury or do any research? All right, everybody says no. Mr. Taylor?
Yes, Your Honor, Ms. Benefield has no further witnesses and we rest on her behalf.
All right, sir. Folks, at this point, it's 4:30. The attorneys and I have some work to do before we can get things going again in your realm of the case. So what I'm going to do is let you go for the evening. If you could please be back tomorrow morning at the jury assembly room around 8:45, just like today. There were probably people down there today. I don't think, was there any civil juries or do you know? There might be a smaller group tomorrow. There might be some judges in civil court picking some juries. So find your area and kind of hang out. And we'll have the deputies come down and get you as soon as we're ready and bring you up and get started. All right, remember the rules for tonight? Don't talk amongst yourselves. Don't talk about the case with anybody else, and no research about people, places, things, or legal topics.
Thank you.
Thank you. Have a good evening. Oh, you all can have a seat.
I can't with all the sounds. All right. The defense has rested. They're going to come back tomorrow.
I'm going to go, and I don't have it in the pile I have with me, but I have a whole other pile. So let me run upstairs and see if I can find
a clip.
Yeah, it was.
Yeah.
So I think what they're going to do now is go. Yeah, I remember that teacup. He said the neighbor was completely convinced that Doug was a monster who was coming after his neighbor Ashley. I mean, that was the neighbor was completely convinced of that story, and who can blame him? Who can blame him? So it looks like we're going to have closing arguments tomorrow. So what I'm going to do, y'all, is I'm going to start my stream closer to the start of their start time, because I just want to be more in line with their timing when they're doing closing arguments and stuff. Because basically they're going to be coming right in and doing closing arguments unless a bunch of more bullshittery with all of the motions and objections, and or maybe the defense is going to try to get in that DNA evidence at the last minute again tomorrow. We'll see. He tries all kinds of little loophole tricks, doesn't he? That's right. He was the first witness, if I recall correctly, Teacup, and he's definitely he's that neighbor you all want. I have those neighbors. I have exactly those neighbors that if someone were to come in and intrude on me, if I needed to call for help, I know they'd come running. So those are great kinds of neighbors to have. Anyway, well, I'm still on the guilty side of things. I still am. And, again, if other people feel differently in my chat, outside of my chat, it's no skin off my back. You're all welcome to your opinion. But I am not buying her explanations. I'm not buying her emotional performances. I'm not buying it. I'm sure that she feels a degree of all those emotions that she's displaying, but but they're more for her, and they're all toward an end rather than for the truth of it. That's how I take it. And I feel like I'm a pretty good judge of character, from looking at all these crimes and looking at, it's been, I've been wrong here. I've been wrong about people. I've been wrong about crimes. I've been wrong about, guilty, not guilty. But most of the time, I'm pretty on top of it in terms of where I come out and who was the abuser and who wasn't, especially in these types of situations. And what I see in their relationship, is a very, very volatile relationship where it could have happened either way. They were both gun nuts. They're both prone to going to that measure. They're both volatile. They're both unstable. They're both manipulative in some way, but she turned out to be the one that, it seems, had more of a motive to, I feel like she did set him up in a way, even if she didn't know she was setting him up. I think a lot of times people who are super invested and wrapped up in their personality disorders and their manipulation, sometimes they don't even know why they're doing what they're doing. They don't know why. They're just doing it. And sometimes that accounts for why they can't explain things very clearly after the fact. And so even if she didn't know that those are all the things that she was doing, even if she didn't know that she left, like, among the very few things you leave in a home as you're moving is a gun, sitting right outside, sitting right out on a hamper. I mean, that's the last thing you leave, and that this man is coming over that you're supposed to be moving with. I don't know. It just, her story just doesn't add up to me. It just doesn't. I feel like she was somewhat calculated, and she was just going toward a specific end, and that she thought she could get away with a self-defense defense. It was a very big risk, and we're seeing just how big of a risk it was at this point. But we'll see. We'll see. So tomorrow I'm gonna start, probably they start at they're starting at 9 a.m. Eastern time. I'll probably start at 9:30 or 9:15 a.m. Eastern time. So I'm gonna get up earlier tomorrow to be on time with them. Yeah, that's right, Patricia. So everyone, please remember to hit the like button. Thank you very much for being here. And please keep an eye out for this stream tomorrow. And I'm planning to go live soon on Checkmate because another straightway leader has been arrested and actually indicted on long-term sex assault charges. Long-time sex abuse and sex assault charges. From years and years and years. Straightway Wilmington pastor, a guy named Pastor Ballard. Jonathan Ballard. Another person of Straightway. Yeah, surprise. So I'll be going live about that maybe tomorrow or the next day. Just to remind everybody about how systemic abuse works. Anyway, so I will see you tomorrow. Have a great rest of your day. Love y'all. Bye.